Welcome to You and the Law. I'm Steve Cilente.
And I'm Bob Lally.
Today what we're going to talk about actually is in response to a viewer's question about how does someone conduct themselves in court. Now, realistically, whether you're a defendant or a plaintiff, it pretty much is the same. There may be a little bit of difference, perhaps, if you're in a jury trial or just a regular court hearing. And that's what break it into two different parts. But of all things we talk about, it's always doubly important when you're in front of the judge or in front of a jury that you conduct yourself in the best possible manner. Now, one of the things we talk about sometimes, Bob, is prospective jurors versus actual jurors. What is a prospective juror?
Well, a prospective juror is a possible juror. They're in the panel box and they will possibly be chosen, and when you're there in the court, you got to remember that they might be one of your jurors.
In fact, a lot of times when a jury trial starts, whether it's civil or a criminal trial, the courts actually bring in a number of different panels. It could be up to 50 or 70 people per panel, and they may be sitting in the audience portion, correct?
Correct. You'd be sitting at front at the tables, and they could fill up that whole room behind you, and everybody's watching what you're doing. And they'll move them up there quite a few at a time. We call it a six-pack, but we do question or ask questions, what we call voir dire, to learn about the prospective jurors so we can make decisions. But yes, the whole courtroom is filled up with quite a few people.
And it's important, I think, in my opinion, that whether you're dealing with prospective jurors, they may or may not be on the jury, or you're actually dealing with a jury, if you're a party to that case, you better behave yourself.
Oh, absolutely, because you have prospective jurors, but then you have somebody who's going to be the actual juror when you have the jurors chosen, and they actually take the place of the judge as far as judging the facts are concerned. They don't interpret the law. They do when they go back in the jury room, but they apply the facts. And part of it is the demeanor.
Demeanor is a very important part, but it really starts before a person gets into a courtroom, correct?
Oh, yes. Oh,
and one of the first things that I tell people is figure out before you get to court what you're going to wear, because what you wear is very important. If you've got notes, other documents, look at them, go over it with your attorney.
Oh, yes.
Start your preparation before you actually get into the courtroom.
Review the case with your attorney and make an appointment to see him long before you get to the trial stage. That's very important so you know what you're going to do.
And I think you and I have both seen instances where it's very clear they haven't done that.
That's true. You need to, when you meet with them, you need to express your concerns about the case and your fears and go over what your testimony might be or is likely to be in the facts of the case. But if you have, you should go over the case completely with the attorney so when you get up to the witness stand, it's not going to be unfamiliar what the questions are going to be, and you'll be familiar with probably what the defense or the other side is going to ask, the plaintiff in some cases.
That's true. And if you know, if you're a plaintiff or defendant and it has not come up in the past, if there's some skeleton in your closet, let your attorney know about it. It's all too often I've seen in court where something will come up and you can almost hear the dialogue between the defense attorney or the attorney and their client, like, why didn't you tell me this? In one case, I actually heard the response is, well, you never asked.
I've heard that before.
Right. Attorneys should never have to ask their client about these skeletons. The client needs to tell their attorney it is confidential, but if it's going to come out in the course of a trial or there's a possibility, it really needs to be discussed.
People should think that there's a big computer in the sky that learns all about them, and that the other side has access to that computer.
Perhaps a topic for another show is one needs to be very aware of the things that you're putting on Twitter or Facebook. We're seeing those things coming up more often in court where your words can come back and haunt you.
Yes, actually, they can be the basis. I've seen them in many cases be the basis of a criminal offense.
Absolutely. Once you know that you're going to court, again, talk to your attorney, or if you're a witness, talk to the attorney, whoever subpoenaed you, and ask them, where do you report? Some courtrooms actually have a witness room or a waiting room. Unfortunately, in this county, we don't have that, but they may have set aside, for whatever reason, a particular area that they want you to wait in. And often they'll give you instructions not to discuss the case with other people who are potentially witnesses, because if you do, that could cause a situation, could result in a mistrial, or perhaps even charges being brought against you for discussing the case when you weren't supposed to.
Correct. One of the things the courts have gone to, taking the precaution, you'll be given a little badge that identifies you as a juror. And part of that is to let the lawyers know that are in the courtroom not to be discussing things they shouldn't around you.
Right. That's true. And we also remember that while jurors are treated differently, but in witnesses, they're not giving badges that I know of. But if you're a witness in the case and somebody starts coming up to you that you really don't know and they start talking about the case, you need to stop that conversation immediately. And then also, whoever the attorney is that subpoenaed you, you've got to let them know what happened.
Right. And you know, you got to appear there on time too. And you not only need to get there a little bit early so you can get there when you're supposed to, because that could, if you're subpoenaed as a witness and you don't get there on time, it could result in a contempt of court if there's not some reasonable reason. If you're a party to a case, it could result in the court finding automatically against you. The other thing is, in a criminal case, if you're not there in time, it could result in another criminal charge being filed against you and your bail being revoked, and like I said, another criminal offense, failure to appear.
It's particularly true in criminal cases where if you show up late or you don't show up at all, you may find that your appearance at the next court hearing is under escort by the sheriff's department because you've been put into custody for failing to appear.
One thing you might want to do is when you enter the courtroom, there's a bailiff they have the machines, the x-ray machines, and they will usually, if you're not sure, ask. I mean, always ask, and the bailiffs can direct you to the appropriate courtrooms.
Right, and in most counties now are posting the court calendars on the outside, at least tell you what department you're in. But we've both seen where sometimes they renumber the departments for whatever reason. So Department 1 or 2 may not be where you think it is. Always ask.
Right, and sometimes they switch departments on you.
That's what I was just
with
saying.
visiting judges, yeah.
That's correct. Remain in the location. In other words, you stay at the courthouse until you're called. If you're not sure if the case is over or something happened because no one's communicating with you, ask what do I do now? I think the case is over with, or I have to leave, I've got a family emergency. Don't just appear. Always keep somebody informed. And the bailiff most often is that person you'll talk to. Do not go in and try to talk to the judge, but at least talk to the bailiff.
If you can just notice the bailiff, with your finger or something, they'll usually come give you a hand. And if you have an attorney, don't leave without checking with your attorney. Lots of times I've had to go to the parking lot. But it's very important that you stay there so you're needed for what you're needed for.
Right.
Yeah.
Be aware of, if you're not sure, always ask questions of the bailiff or the attorney. One of the things that we see now are specific rules saying no food, in many cases no bottled water in the courtroom. Don't bring reading material, newspapers or other things. Lawyers can often get away with reading a law book because they're researching something while they're waiting for their case, but it really looks bad, and courts are not going to stand for you opening up a newspaper and reading it. They're very disruptive and noisy.
I'd like to comment about that, if you would, for just a minute, because, as you know, my father was a judge for many years, and that was one real irritant, is people, when they opened up something and read, because they weren't paying attention to what was going on in court. And he wanted everybody's attention so that everybody would know what they were supposed to do.
I remember one case where a juror started reading a book in the middle of the trial.
Oh.
Fortunately, it was not my case, but it didn't go over well with a judge. Turn your cell phone off. Now, some courts will allow you to put on vibrate or silent. That's fine. I do know of one court that will actually take your cell phone away from you, and you're not going to get it back for 30 days. And certainly the court can escort you from the courtroom if you violate their rules, whether it's chewing gum or whatever it is, talking during a court session. You may find yourself in a situation of being escorted from the courtroom, even if you're a defendant, which means they'll tell you to wait outside, we'll come and get you when your case is called. Never looks good.
I think it's a good practice before you enter any courthouse. Take that cell phone out of your pocket, open it up, and really make sure it's turned off.
Absolutely. Next thing we ought to address, not to coin a
They got a
phrase,
good pun there,
is
Steve.
the dress.
Right.
There is no particular dress code. Attorneys, yes. Men, unfortunately, we still have to wear ties.
Ties and
Notice
suits.
we're not wearing any now. We're not in court. But you have to wear ties. We've got to wear jackets. I tell my clients I'd like them to look at least as dressed up as much as I am.
I actually have a little different approach. I say, dress like you're going to apply for a job position.
That could be dangerous. I think that people ought to dress conservatively, try to look good. We used to say, like, going to a Sunday church meeting or something.
Exactly.
I think we've all seen, as lawyers, seen situations where people show up in tank tops, see-through blouses, obnoxious writing, like what the judge can do with himself, written on the front of the T-shirt. A lot of these things don't go over real well with the judge. Judge is not going to say anything most often unless it's highly inappropriate, suggestive language. But to a jury, if you're a plaintiff or a defendant, your case may be over at that point.
And there's a couple of things here, a couple of rules, which I can guarantee to you. If you wear loud colors or you come in dressed totally in black, nobody has to say anything, but you will be remembered. And it won't be in a good light, and it will be by every attorney in that room, and be by every probation officer in that room, or every court official, and first impressions count. And that will be your first and lasting impression.
There is a saying about you don't get a second chance to make a first impression.
Particularly in a small county.
Absolutely, in a small county. And another saying that good guys don't wear black. Now, attorneys, we've got black suits, brown suits, all colored different suits. But for a client to show up, especially if they're a defendant in a criminal or civil case, they're wearing a black shirt, a black jacket, black pants, may not be appropriate. Now, if you're a minister, it may be wholly appropriate.
That's absolutely
but
appropriate.
if that's not the case,
Yes.
probably a good idea. Talk to your attorney or whoever subpoenaed you. Ask them what would be appropriate.
Now, sunglasses. Can I talk about that for a minute?
Absolutely.
That's like wearing loud orange or loud brilliant yellow colors or wearing black. It's just odd. It's just plain odd to look in a room and see somebody with sunglasses. And it's just not appropriate. It looks like you're hiding something. Please don't do that. But also, people cannot see your eyes if you wear sunglasses. And people can't, they want to see your eyes to see if you're telling the truth or not.
Some people do believe that there's a lot of truth that comes from the eyes. Now, there are situations where, for instance, you've been to an optometrist, you've had your eyes dilated, you've got to wear sunglasses for your own protection, even inside of a lighted building. The bailiff is probably going to accost you when you come in and let them know you've got a particular situation that requires it, so that it's not a problem. If necessary, even bring a doctor's excuse to show this is why I've got to have these on right now. I actually saw an attorney that had to go through that process because they had on the weird glasses you get from your optometrist when they
Right.
dilate your eyes. And that attorney was allowed to wear them through the entire process because it was really a health-related issue. Now, the other thing that we often see, and this is most important when you're dealing with a jury, if you're female or today's world of male, be cognizant of what jewelry you are wearing. Criminal cases where you're defendant, in civil cases where you're a plaintiff, obnoxious jewelry, and I'm not picking on anybody, but some jurors, particularly if you've got a very conservative jury, men with earrings, but particularly the very large ones with the hole in the middle, the donuts, whatever they're called, talk to your attorney ahead of time, see if it's appropriate or not appropriate. Having guys come in with a lot of earrings to the jury, the attorney may tell you that will not go over well with the jury. You know, people are, when they get up there in that jury box, are supposed to be unbiased. But realistically, we all have biases.
We're all human beings.
Well, most of you are. So also be careful, I would say, of making a political statement.
Yeah, before I move into that, keep in mind of what kind of case you have and the kind of image you want. If you go there for a personal injury case, I've seen people wear very expensive jewelry who are asking to be compensated because they had losses. Now, if they had losses, why are they wearing the expensive jewelry?
Yeah, Rolex doesn't go over well in front of the jury.
No, it does not. But you want to avoid items that have a personal association of a belief. That's the courtroom. Some of those beliefs are litigated, but this is not the place to be expressing that. Political buttons, club pins, college rings, religious jewelry may trigger some prejudice against you in the mind of the juror. We all have our beliefs and we all want to stand behind our beliefs, but standing behind it at the inappropriate time may turn it against us as far as court is concerned and how other people feel about it in court. Of course, if you're a member of a motorcycle gang, you don't want to wear a jacket and be affiliated with any motorcycle gang.
And that brings up tattoos.
That's true, true. Especially if you're in the criminal courts. You want to be very cognizant of it. People have the tattoos, they're wearing them all the time. They don't realize what the environment they're switching into.
And when you mention tattoos, we're not talking about the tattoos we see a lot of people wearing today. There are certain tattoos like across the knuckles, teardrops in the eyes that are a little hard to cover up. But there are certain tattoos that have gang affiliations, for instance, that may turn a jury off. And even if you're 100% right, they're going to see that just like they would see the Rolex watch and saying, hey, this is a bad person, or this is a person that shouldn't be compensated because they've got a lot of money. And you may not want to be advertising that to the jury. Again, talk to your attorney, ask them about it, and if you're told wear a long sleeve shirt, you ought to do that.
Absolutely. I'm a firm believer that if any tattoos, if you can cover them up for court, they should, because you don't know who they might offend. Some people are offended just the fact that they are tattoos of any nature.
That's true. My dad said if I ever got one, he would remove it himself. But you've got to dress to fit the audience. Now, obviously, if you're just going to be talking to the judge, just wearing a sports shirt, clean pants, and I do mean clean. We have people that look like they just crawled out from underneath about 50 different cars. But you have to meet the expectation of your audience. You want credibility when you testify, or you're the defendant or the plaintiff, whether or not you are testifying. You've got to play the role, as it were. You've got to look like you're either professional or certainly at least clean cut.
Yeah, can I make a comment on, For example, if somebody works in a service station or a car wash or something, and they have a uniform with their name on it or something like that in courts during the day, and making an appearance before the judge, that uniform I think would actually be okay.
As long as it's clean.
As long as it's clean. One thing is going to tell the judge you're working.
And that in today's world, that's always a good thing.
Yeah.
But one has to remember that sometimes even a small flaw in your appearance is going to be judged by the jury.
Absolutely.
And they may not be to your benefit or be to the benefit of your case, so you always have to be aware of that.
We don't know what jurors are swayed by.
Exactly. What a lot of people don't understand, that it's not just the testimony that the jury is evaluating. From the time that a jury is sworn in, they know who the defendant is, they're immediately told what the case is about. They start looking at the defendant. They will watch every move. They will see how they're dressed. How do they conduct themselves in court, which we're going to talk about in a minute. But they're essentially under a microscope. Whether the jury's been impaneled or not impaneled, everybody is watching them. The judge, on the other hand, you can relax a little bit, but there's still a lot of rules that we're talking about that the person needs to follow.
Oh, yes, and the judge will take notice of any conduct within his court because that's his bailiwick. That's his kingdom,
Right.
pretty much.
And this, I'm going to talk briefly here about courtroom demeanor. One of the things I threw under demeanor was that sometimes people have special needs. Whether it's they can't see well, they wear dark glasses, they may be blind, they can't hear well, they're in a wheelchair, they have some special need. I've had clients that were incontinent. In the middle of testimony, they'd say, "Excuse me," and we would immediately stop the proceeding. They would go take care of their issue and come back. But you have to tell somebody ahead of time, your attorney, the bailiff, whoever it is, you have a special need. The courts are very good about accommodating people with special needs.
One of those is hearing. They have hearing devices. You just have to ask for the hearing device, and you can mention to your attorney, and your attorney will see that you provided with that.
Exactly. And we talked about very briefly a minute ago or a second ago about your demeanor in court, and people are watching you, okay? And when they watch you, they're watching, if you're sitting at the table with your attorney, they're going to see whatever is going on up above that table.
However you communicate, if you go over and kick them underneath the table.
Right.
Right.
But one of the issues that I've paid attention to in court when somebody is testifying is what is the reaction, whether it's the reaction of the attorneys or reaction of other witnesses. I look for the reaction of jurors, but those jurors are focused on the defendant's reactions most often.
Right, and body language conveys meaning. And the jurors, that's what they're looking for. They're looking for people. People react through facial motions, and people can read those facial motions. So that's very important. It's very important. One of the things is like rolling your eyes, or the way in which you speak. Don't mumble to yourself, or stage whispers about ongoing testimony about the opposing attorney. You want to appear, I think the word is credible, wouldn't you say?
Exactly. You certainly want to look credible, but you don't want to be putting on a show for the juror.
Oh, they can tell if you are.
Absolutely. You mentioned rolling of the eyes. We see that quite often, or any facial expression, raising one's eyebrows like, you've got to be kidding. The jurors do pick up on that. And as an attorney...
And the judges do too.
Absolutely. That's one of the reasons why I watch the jurors, and there are times when I've leaned over to a client and told them, quit doing this or quit doing that, or you need to, put your head up, because they're sitting there just staring down at the table.
Or speak up. It's how you speak as well. I'm sorry.
Right.
Yes.
And the other thing you talk about stage whispers, like when they lean over toward you, or you see them lean over toward their attorney and say, "That was stupid." And of course, everybody in the courtroom heard it.
There's microphones there now.
That's absolutely correct. And almost anything that's said at the table does transmit. Mm-hmm. And that brings up personal quirk of mine. I've got a bad habit of tapping a table with my pen occasionally. with those microphones. It sounds like I'm pounding on the table, so I have to watch that. Don't scribble your notes to your attorney. We see that often. The attorney is trying to watch and you're trying to talk to your attorney. You're writing notes and shove it in front of your attorney. They're trying to figure out what's being said. They've got to listen to it, wait till a break, or at least minimally write it down and wait. The attorney will look at it when it's appropriate time. Let's jump ahead a little bit, Bob. I think the common things about, don't be rattling things in your pocket.
That's one thing I'm guilty of sometimes. Yeah.
Right? Don't chew gum. Certainly in this court, they'll tell you to swallow it or spit it. Well, they tell you to spit it out. They'll give you a Kleenex to do that. Well, I actually saw a situation where a person coughed and that gum went shooting across the courtroom. That went over real well.
Well, it interferes with speech as well.
Absolutely. Don't use your hands unless, I do use my hands all the time.
We're doing that right
But
now.
for the most part, keep them in your lap, keep them folded. Again, everybody is watching you and the jury is evaluating you.
Yeah, remember that at all times you're not being watched. Forget the word watched. The word is evaluated.
That's good.
And judged. Judged and evaluated.
The other thing we often see is somebody crossing their hands when they're on the witness stand. I'm shutting everybody out.
That's like I'm closing the world off.
Absolutely.
Yes.
Very negative
Yes.
body pressure. Again, you're being evaluated the entire time. And that brings up something that just occurred to me. Oftentimes during breaks, you see people walk over and start talking to somebody. That's why we put badges on jurors. Do not ever talk to a jury when they're impaneled during a break or at any time. That could cause problems, could put you in jail.
Briefly, that could cause what we call a mistrial, and the whole trial will have to start again, and you could be responsible for that.
Absolutely. And a real important thing I just want to touch on very quickly is that what a lot of people get into trouble is that they'll answer their attorney's questions in a voice much like I'm using now, but when the opposing attorney asks questions, yes, no. Their whole style of answers changes, and you can't do that. You've got to answer both attorneys' questions identically.
Exactly, and the judge will actually instruct the jury that they can consider those things.
Absolutely. When a lot of times, we're pushing real quickly at this point, but diagrams. Most often it's professional witnesses that have to do them. We tell them, prepare them ahead of time and show which way is up or north. Be prepared when you go to court, always.
True. That's part of meeting with your attorney and working it out ahead of time.
Right. Remember when you're in that courtroom, you address everybody in a very popular or professional manner.
Yes.
You don't call a judge by their first name. I've seen that.
Don't say nope.
You say yes or no. Don't mumble. Don't take shit. Don't use the shake of the head. All right? Be professional. I refer to the judge as Your Honor, Mr. Bailiff, Madam Clerk. Exactly. You've got to be professional at all times. Remember that when you're in the courtroom, whether it's as a spectator or otherwise, somebody is watching you. Ladies and gentlemen, we thank you for your attention and your time for watching us today. If any time you have any questions, please write to the station. The website, I believe, is going to come up here in a second. And let us answer your questions the best that we possibly can. Thanks for joining us today on You and the Law.